Welcome back to Law and Crime Live. I'm your host, Caroline Polisi, and court is on lunch recess in the case of Claude Tex McIver. We're seeing now the defense put its case on to the jurors, and I have to say, they're doing a really good job. We heard this morning from Ross Gardner. He was still on the stand here, getting down now. I think there are a few last questions to ask Mr. Gardner before he leaves as a witness, and that'll be after lunch break. But I'm joined in studio with Sanford Rubenstein. Thank you for being with us here today. You are a civil rights attorney, and we also have on the line at Skype, we have Joseph Scott Morgan, our forensic death investigator. So both of you, I want you to break it down. What is going on? You know, we've been talking, first to you, Sanford, we've been talking a lot in this case about when the prosecution's case was on, how we didn't, the general consensus here at Law and Crime was that the prosecution hadn't met its burden. What do you think the addition of the defense case has done to the prosecution's case at this point?
Well, if there was reasonable doubt in the minds of those here that they hadn't met their burden, this adds to that reasonable doubt,
right,
and certainly demonstrates that there is a viable defense here in terms of this indictment for murder being dismissed by this jury based on the testimony of this witness who basically says the gun could not have been pointed, it had to be laying on the side. No one's answered the question, though, what are you doing leaving a gun cocked in your lap?
Right.
That's another issue that if I was a juror in this case, I would certainly wonder about, because it certainly helps the prosecution.
Right. Joseph, what do you make of the forensics that we've gotten into this morning on the stand with the defense case? Do you think, look, you know, he had been questioned over and over again. He said multiple times he couldn't state whether or not, in his professional opinion, this was an accidental discharge or not. However, I think the rest of his testimony was quite compelling. What did you make of it?
Yeah, it is very compelling. Ross went to a great degree to kind of be as demonstrative as possible. One issue that I have with the model that he's using there that flashed up on the screen is that he's using a semi-automatic dummy pistol to demonstrate this. That's not the type of weapon that was used. It was a snub-nose airweight 38 caliber pistol, which is a revolver. So it changes the dynamic. It's also, they have the ruler there in place to show range of fire in this particular case. But what he's saying is still accurate to the degree that it's a very confined space that McIver would have been positioned in. And there are a limited number of attitudes that his body could have been in when this weapon was discharged. And at some point in time, as this weapon is resting on his lap, I think one of the reasons they concluded that it was resting flat on his lap, if you look at how confined the space is, he can just slightly turn that weapon or reorient it down into his inner thigh, and suddenly he's in the line, he's targeting himself when this weapon discharges. So there's a degree of self-harm that's involved with this. That's why it also gives us pause, as esteemed counsel was mentioning a moment ago, regarding reasonable doubt. You know, would somebody with reasonable faculties about them put themselves in a position with a cocked weapon so that they might in fact shoot their own selves in the leg? If you were purposed to shoot this person, as we've discussed before, Carolyn, it would seem that you would take this weapon and drive it in the muzzle into the back of the seat and discharge the weapon. So I think that Ross Gardner has done an adequate job here in painting a picture that the jury can understand. One other thing that I think that really needs to be emphasized in this vehicle, that front seat can, in fact, as Ross said, be manipulated into multiple planes. And there is no guarantee in this particular set of circumstances that the seat has been, or that the vehicle was secured to the point where no one had manipulated the seat prior to the police examination and certainly prior to Ross's examination of the vehicle. It can be pitched back, it can go forward, and not just forward with the rear of the seat, but the base of the seat itself, where your bottom rests, that attitude can be adjusted as well. And so again, that goes to reasonable doubt, and I think that gives a lot of purpose to the defense's case that they're putting forward.
Right, and when you add sort of the forensic elements you detailed there with, of course, we heard from the masseuse yesterday about sort of every time that she gave Tex McIver a massage, she would fall asleep. And so we have this element of sort of being awoken from a sleep. Also, we're hearing sort of rumblings of perhaps maybe he had a sleep disorder. He was, his hands would jut out at certain times. So when you combine the two of those together, I think you really do get to reasonable doubt. But what I want to play for our viewers right now is the direct examination of Ross Gardner. We just finished up some of the rebuttal there, but I want to play you a clip of Ross Gardner. He's the defense's witness here, the crime scene analyst. So take a listen. All right, that was testimony from Ross Gardner, a defense witness, a crime scene analyst in this case, just moments ago, really before the lunch break. That was his direct examination. So, Joseph, I want to throw this to you. We've been hearing a lot about trajectory and angle of elevation, and so I need you to help us figure out what all that means.
Yeah, what he's referring to is the orientation of the tip of the muzzle, that is the end of the weapon, okay, relative to the position that Mrs. McIver was in and the position in which McIver himself was holding the weapon. And this is going to give you an idea as to what the down angle on this is. He's saying that the tolerances within the practice of crime scene reconstruction are up to 5 degrees, okay?
Meaning that's the window of error?
Yeah, the window of error. And so they're, they're well contained within that, according to him, what some people in vernacular would say what the industry standard is. So,
right.
Right now this is kind of a nitpicky kind of thing that they're going back and forth with. But, the data that Ross is putting forward here can be rather complicated. As he stated, there's a lot of trigonometry that's involved when you're reconstructing firearms-related cases. And this is an area that Ross works in every day. He's also considered one of the top blood spatter analysts in the world. He's written the definitive text in this. And there's a lot of similarities between these two things. And so he's trying to paint a picture for the jury and break this down in terms that folks on the jury can understand and try to make it a little less convoluted. You saw that Mr. Rucker kind of got his hair up there when he mentioned that this was done in the lot at APD. There was, I don't know what the final conclusion with that was, but, Ross stated that he was in a garage. He also made reference to the fact that the battery was dead by then, that the seat couldn't be adjusted. So he's trying to paint this picture, at least in a subtle manner, of he was under different circumstances and different conditions when he was asked to examine this vehicle. And this is very common. If you're working for the defense, you're not going to have the best of situations many times there that you're placed in order to reconstruct these things.
Right, and of course we have that blue line on the 2-inch mark above that gun, which would indicate, as the prosecution has been pointing out, that the gun used for this specific reconstruction was not the kind of weapon actually used in the shooting.
No, it wasn't. Completely different. The barrel length is different too. And again, when you're talking about angle of deflection, this is going to put your pitch off slightly.
Right.
So I think that that's something that, if I was prosecution, I would want to emphasize quite readily in this particular case to kind of punch holes in what the defense is putting forth.
Right, right. So interesting. I also think what was interesting about this, just as defense witnesses go, he was very upfront about, I think the prosecution was pointing out that he had made a bit of a mistake, and he readily admitted to it. He just made a mistake on that DNA evidence there. But we were all talking off camera. We don't think it's that big of a deal.
No.
The prosecution would like to have us believe that this is, a huge deal, that he made some, big mistake going to really the key question in this case, and you could explain that it really doesn't matter.
If anything, it shows his credibility.
Okay.
It shows you that he's presenting a credible witness to the jury.
Right, exactly. Meaning Sanford's point is, I think he only gains credibility in the eyes of the jury for standing up and owning his mistake, right?
Yeah, I'd agree. I'd agree with Sanford in that case particular, because if you're willing to, instead of dance around it, just make the admission. And look, Ross freely said, he says, I don't do DNA examination. Right. I was basing this upon the report that I'd read, and he essentially misstated what the findings were. And just so the audience at home understands, one of the things that we talk about, even in my college classes I teach at Jacksonville State, is the fact that just because someone's DNA is present, let's say for instance on a weapon, doesn't really amount to a lot, particularly if they're the owner of that weapon.
Right.
And that's one of the things that they were going to in this particular case, that whether there was McIver's presence, DNA was present on the trigger, or was it not? And so it is rather moot.
Yeah, good point. Good point. So we're going to take a quick break right now, commercial break, but we'll be back on the other side. Also, I want to let viewers know that we are hearing about Tex McIver, whether or not he's actually going to testify in this case. So the judge will be hearing from attorneys on both sides around 1:40 live in that courtroom. So we will get you back there live just as soon as we get that feed up. You won't want to miss a second of it on Law and Crime Live. Welcome back to Law and Crime Live. I'm Caroline Polisi, and court is on lunch break right now in the case of Claude Tex McIver. I'm joined in studio with Sanford Rubenstein, civil rights attorney, and on Skype with Joseph Scott Morgan, forensic death analyst. So, guys, before we get back into our discussion, I want to play one more clip of Ross Gardner. He is the defense witness, the crime scene investigator, who is really just blowing the lid off of the prosecution's entire case. So I want our viewers to make sure that they are up to speed on that. So take a listen to this clip. All right, that was testimony from Ross Gardner just earlier today in the case of the Claude Tex McIver trial. Joseph, I want to ask you, I know you're only on with us for a little bit longer, but what is the significance of this line of questioning about the pattern on the back of the seat? Why is that relevant here?
Okay, brief lesson here for our audience. When the weapon is fired, the bullet is not the only thing that comes out of the muzzle of the weapon. We've got smoke, we have a bit of flame, and we have unburned powder and any kind of other debris that's in that muzzle. So as it disperses out of the end, it begins to spread. Now you've got the bullet, if you imagine the bullet coming out, this cloud is growing wider and wider the further the distance is to the contact point. What we determine is that wherever the disbursement pattern is, that's going to correlate back to the distance it was from the end of the muzzle to where the bullet entered the target. And the initial target is the rear of that seat. That's why what Ross is talking about is the deposition of soot and powder on the back of that seat. It's real simple. Just imagine that if it's really spread out like this, the further the distance. And you can measure this out to about 18 inches, Carolyn. After that, it's kind of it is moot because powder begins to fall away greatly after that period of time, and then it becomes an indeterminate range. But what Ross is saying, and this is critical, is that this paints a picture for the police, for the defense, and more importantly for the jury about relationship between the end of the muzzle and that target location. It confirms that the weapon was not pressed into the rear of that seat, that it was fired at some distance. One other thing. Early in this clip of testimony we were talking about, he was talking about the angle that the weapon had to be held at. If that weapon is actually turned, if it's turned upward like this, okay, if it's turned up so that the hammer is up in the air, okay, as opposed to on its side, if it's turned like this is going to throw your angle of deflection off by another 2 to 3 degrees. So this is where the deflection angle comes in to play here greatly. That's why he's saying it's reasonable that you could turn the weapon on its axis like this, have it on the side. You could even twist your arm all the way around and you're going to get that same attitude. But if you twist that weapon all the way up in what people normally think is a standard orientation, the trigger guard comes into play and the pitch increases on it. So the degrees will be off from what they were talking about.
So interesting. Do you think that the jurors in this case are able to absorb this type of really complicated scientific testimony?
I think they are. And, you know, the mark of a good expert witness, whether they're for the prosecution or defense, is can they take complex scientific constructs and break them down to a group of people that don't have as sophisticated an education as, say, a lot of other people, or maybe their interests lay in different areas. I've always tried to pride myself on that and teach my students that as well. You're not there to impress the entire world. You're there to get a point across. Yeah, I think that it is. Now, if you start to get off into the areas of like toxicology and DNA, it's a bit more difficult, but this is kind of practical stuff.
Right. Joseph Scott Morgan, everyone. That's why we love you, having you on Law and Crime, because you do it so well. You break it down for us because we need to know these answers. So thank you for being with us. We know you have a busy day. So we'll sign off. Joseph Scott Morgan, forensic death analyst. Thanks.
Yes, ma'am.
And Sanford. Now,
I want to add something also on that issue. The defense lawyers will have a chance to spoon feed to the jury in summation what he said as an expert and make it perhaps less complicated. So this jury will have heard from him, and then they'll hear the defense talk about what he testified to on the stand to spin it to them in a way favorable to their client.
Right. Very good point, Sanford. I think we often talk about, as defense attorneys or even prosecutors, you take little pearls from each one of your witnesses to bring it all together in summation. I want to switch gears a little bit and talk about this testimony that we heard yesterday, Thursday, from the masseuse, Annie Anderson. She was on the stand. Now, of course, McIver is accused of murdering his wife, Diane McIver, and the prosecution has put forth this working theory that maybe Anderson and McIver may have been having an affair. I want to play our viewers a clip of her testimony from yesterday, and Sanford and I are going to discuss it on the flip side. All right, a heated exchange there with the now infamous masseuse Annie Anderson claiming 100% she did not have a sexual relationship with Tex McIver either before or after Diane's death. I'm joined, of course, in studio with Sanford Rubenstein. Thanks for being with us. Yes.
Now, that's so important when it comes to motive, because the prosecution is trying to show motive is financial motive and now perhaps a girlfriend in the picture. And it's clear that she had no sexual, assuming she's telling the truth and the jury believes her, she was not in a romantic relationship with him. She never had a sexual relationship with him. So there goes that as a motive.
Right. So where does the prosecution get off sort of floating this theory if it sounds like they really had nothing to the theory besides the fact that, look, she was their masseuse. We heard there that she gave massages both to Diane and Tex. But, what are the ethical obligations on the part of the prosecution to pursue this theory, this motivational theory, when really it seems like there's absolutely nothing to it?
Look, the prosecution is putting seeds for thought in the ears of the jury. Look, the jury may not believe her and believe there was a sexual relationship from whatever else is coming out. Bottom line is, this case will turn on two factors: motive and reasonable doubt.
Right. So if we now think we don't have this motive here of the sort of, secret lover, let's call it, in the masseuse, what other motivation do you think they have?
Well, the motive that they're trying to show is that he was not in a strong financial position, that he was financially going downhill, and that he needed the money that he would get from her death to straighten himself out. And I think that's the only motive they're really left with.
But don't you think now that that has really fallen flat at this point? I mean, we've heard from witness after witness, and we just can't get a solid verification that her death would really benefit Tex at all.
Well, there's no question from the testimony her death would give him a greater net worth than he had before. But he does have assets. He's not going broke. I don't see him going bankrupt. Bottom line here is reasonable doubt.
Exactly.
Is there reasonable doubt? And if there is, this jury has an obligation to acquit.
Absolutely. Let's hear a little bit more from Annie Anderson from yesterday, just quite frankly, because the testimony is riveting. And we'll be back on the other side talking with Sanford Rubenstein. All right, some tearful testimony there from Annie Anderson, of course, the former masseuse of Tex McIver and Diane McIver, actually, getting to the heart of the matter there about what Danny Joe, of course, Diane's best friend, told her happened that weekend. I'm joined in studio with Sanford Rubenstein. Thanks for being with me today. We're about to go back live to this courtroom, and we're going a little bit early because prior to the jurors coming back from the lunch break, the judge is going to hear from the attorneys on both sides about the prospect of Tex testifying. So, I mean, I think any defense attorney, prosecutor you ask would say that typically the standard wisdom, standard practice is you never let a defendant testify. It's just not something that you do. I want to hear from your perspective what you think Tex's testimony could do in this case.
Well, I think if Tex testifies, his testimony is going to turn this case one way or the other. The question his attorneys have to answer for themselves and for Tex is, do they have enough in this trial to get a jury to acquit? Or do they need him to testify to explain how this gun went off accidentally? Looking face to face with the jurors. That's the question.
Right. And what do you think? I mean, I personally don't think they need Tex to get up on the stand. I think the defense has actually done a really good job poking holes in the prosecution's theory. I think their case that they're putting on, by all accounts, is pretty good.
Part of the problem you have is that clients don't always do what their attorneys tell them to do. Here you have a lawyer. Here you have someone who has, in many different ways, tried to influence the end result of this trial. I see him testifying. I think he is going to say, I want to take the stand. I won't listen to your advices as my lawyer. I'm going to take the stand because I know what really happened, and I want to tell this jury. Whether his lawyers can convince him not to, that it's too risky, because he does have to stand cross-examination. He has to withstand, I'm sure, a withering cross-examination here with regard to a number of issues that have come up during this trial. Let's see what happens.
Let's see what happens. Wow, that is a bold prediction. I definitely do not think he's going to take the stand. I think that if he does listen to his attorneys, they should be telling him, you don't have to do that. It's just not a wise choice to roll the dice in that regard. Again, I'm keeping a close eye on the courtroom because we did hear from the judge in this case that he wanted to hear from the lawyers for both sides about the prospect of Tex McIver testifying in this murder trial. I want to throw to another clip of Annie Anderson, the masseuse from yesterday. All right, the jury is being led into the courtroom right now in the case of Tex McIver. We just heard a colloquy between the judge and the defendant, Tex McIver, in this case about his decision about whether or not he is going to take the stand to testify. And Sanford, you were proven wrong.
I was wrong. I was wrong.
You were.
This defendant is listening to his lawyers, who in all likelihood said, do not testify, and he took their advice.
Yeah. I hate to rub it in your face, but I was right. Yeah.
Probably doing a smart thing.
Absolutely. Always a smart decision. Now, I just want to make sure we're not going to miss anything in the courtroom right now. Do we want to go back live to the courtroom, guys, with the jurors coming in now? It looks like the judge is giving the jurors some instructions, so I don't want you to miss it. So let's go now.
Next witness.
Follow-up questions, the rebuttal questions from the prosecution. So there's a short break now. I don't know who's leaving the courtroom right now that you see up on your screen. But Sanford, I want to talk a little bit about this sort of, I mean, it's not really a bombshell, but the fact that Tex McIver will not be taking the stand in his own defense in this trial. No surprises for me, but oh, and we're hearing from our producers now that the defense has rested its case. So that is it. That is the entirety of the defense's case. We knew it was going to be very short. Let's go back to court live now to see what's happening. All right, that's it, folks. The defense has rested its case in the defense of Claude Tex McIver. That's a pretty big deal. The entirety of their case, I think, rests on the testimony we heard earlier today from Ross Gardner. He's the crime scene analyst. It sounds like we're going to have a short rebuttal case by the prosecution prior to closing arguments. The judge there just telling the jurors to take sort of a what they would consider to be a post-lunch break, even though they just got back from lunch. But it sounds like court will resume in a little bit, and we'll take you back to the courtroom live just as soon as sort of the jurors have been shuffled out and there are continuing motion practice in front of this judge. Sanford, what do you make of this? Case closed.
At the risk of being wrong again,
yeah.
I would suggest that the prosecutors are going to put up a rebuttal witness to this last expert, perhaps their expert who they already called to rebut some of what he said. I'll be surprised if they don't.
Good point. Let's listen into the court to see if that's exactly what they're doing.